Welcome everyone, this is Amer from UCounsel. Today we'll talk briefly about workplace investigations. What is a workplace investigation? What is its purpose? What are some of the goals? How is a workplace investigation instituted? And what are some of the steps taken in a workplace investigation so you can get a basic understanding of a workplace investigation, whether you are an employer or an employee who is involved in an investigation. We begin with our usual disclaimer that this lecture is not legal advice, so if you have any specific questions, you should contact a lawyer or a paralegal or the Law Society of Ontario for any referrals. So workplace investigation is to investigate a workplace dispute. That's one of the common reasons. Also, there could be an allegation of improper conduct, for example, harassment complaint by an employee against a coworker or a manager or supervisor, or a discrimination complaint, or a complaint of any other conduct that is considered to be improper. You may, as an employer, need to investigate that. There may be a workplace accident or an injury that requires an investigation, and that could be a reason. Or something, or another occurrence, something else that may have happened in the workplace that warrants that the employer should investigate that particular occurrence. So what is the purpose of an investigation? The fundamental purpose of a workplace investigation is fact-finding, to figure out exactly what happened. That is the most basic and the most essential purpose of a workplace investigation. Who said what to who? What was the incident? How did it happen? Who were the parties involved? So essentially all the important elements of that specific instance or instances, and to figure out all the facts that are relevant to that particular issue. So fact-finding is one of the most essential and sometimes the only purpose of an investigation. The investigation could be much broader than just a fact-finding mission, but essentially it has to be a fact-finding mission. Other purposes could be to identify breaches of policies and procedures. So if the employer has any policies relating to that instance, then the employer may want to know whether a specific policy or policies or procedures were breached. So for example, if it's a workplace incident involving the use of a specific machinery, were there any policies relating to the operation of that machinery, and whether the policies were followed, or if not, whether the procedures were breached, and if so, who did that? So some of the issues, purposes of the workplace investigation could be to figure that out. Also, one of the purposes of investigation could be to figure out any breaches of law. And this could be different than the policies and procedures, because policies and procedures may be limited to that specific employer, may not necessarily be a legal obligation imposed by law. So another purpose of a workplace investigation could be to figure out breaches of law, whether there was a discrimination contrary to Human Rights Code, whether there was any harassment contrary to Occupational Health and Safety Act, whether there were any other breaches of law, whether the alleged act was a criminal act and warrants any criminal investigation. So all of these things may be part of the investigation process. Another purpose of investigation could be to obtain recommendations from the investigator so that any future issues of similar nature could be avoided. Also, the employer may ask the investigator to provide a legal opinion on the matters, and also the employer can ask the investigator to provide any recommendations whether any legal action is warranted against any of the parties who are involved in that issue. So what is the obligation to investigate? The investigation could be done in one of the two ways. One form of investigation is under Occupational Health and Safety Act in Ontario, and there are similar legislations in other provinces. I'm not sure whether other provinces mandate a workplace investigation, but in Ontario, under Occupational Health and Safety Act, the Act requires, it imposes an obligation, mandatory obligation on the employer to conduct a workplace investigation when there are issues relating to harassment. So here's the Occupational Health and Safety Act. section 32.0.7 sub 1, to protect a worker from workplace harassment, an employer shall ensure that an investigation is conducted into incidents and complaints of workplace harassment that is appropriate in the circumstances. So it is important to recognize that the language that is used is to conduct an investigation. Number one, it's a mandatory obligation to conduct investigation. And number two, investigation needs to be conducted into incidents and complaints. So sometimes there could be a potential workplace harassment, but there's no complaint actually filed with the employer. But employer becomes aware of an incident which may be considered a workplace harassment. The obligation to investigate is still on the employer to conduct a workplace investigation. And obviously when there is a complaint, then the employer has an obligation to conduct a workplace investigation. The other section it's worth reading here is with respect to the investigation is that the worker who has allegedly experienced workplace harassment and the alleged harasser, so both parties, if he or she is a worker of the employer, are informed in writing of the results of the investigation and of any corrective action that has been taken or that will be taken as a result of the investigation. So parties, the person who has made the complaint or the person who has experienced workplace harassment is entitled to know what is the conclusion of the investigation, and secondly, the person who has been accused is also entitled to know what is the outcome of the investigation, and this needs to be done in writing. So Occupational Health and Safety Act mandates the employer to conduct an investigation with respect to workplace harassment issues. Otherwise, the employer has its own discretion to conduct an investigation. If it's not a harassment scenario in any other circumstance, the employer may decide that a workplace investigation is appropriate in the circumstances and may choose to conduct an investigation. Example of such an investigation could be an investigation into any discrimination or potential discrimination issues. The Ontario Human Rights Code does not mandate an investigation, so the employer may choose to conduct an investigation to figure out whether there was any discrimination based on the facts of the case at hand and to take appropriate action. So aside from the Occupational Health and Safety Act, there is no obligation, but based on the specific circumstances of the issue, the employer may choose to investigate. And just so you know, workplace investigations have now become a common thing, primarily because employers want to make sure that they understand what has happened and to protect other employees and the employer itself from any legal actions that may flow from that specific instance. What are some of the goals of a workplace investigation? It is tied to the purpose of the investigation, but one of the goals of the investigation is to figure out what legal action, if any, needs to be taken based upon the issues that have come to light in that specific investigation, and if there are any remedies that needs to be obtained with respect to that investigation. That is one of the goals. Another goal is to make sure that the workplace is repaired. If there is a breach in relationship between co-workers and employees, then that is repaired and you create a work environment which is safer and cordial, and also to make sure that if there are issues with any policies, either with respect to the policy itself or with respect to any training or any other facts relating to workplace policies, then that is looked after. Obviously, the employer wants to make sure that the workplace is more productive and safe for all of its workers. And finally, the employer also wants to make sure that similar issues do not arise in the future. Now, how is a workplace investigation instituted? First of all, as I said, the employer may become aware of the issue, so the knowledge of issues or dispute or the occurrence, and then the employer, because of that knowledge, the employer starts the process of deciding whether to conduct an investigation or not. Or the employer may have received specific complaints from an employee with respect to an issue, and that may trigger the inquiry of whether a workplace investigation needs to be conducted. And once that knowledge of the issues is being made aware, then the employer conducts normally a preliminary review, usually done by human resources department if the employer is big enough to have a dedicated human resources department, or someone who is in charge of human resources issue will conduct a preliminary review and decide whether an investigation is warranted in the first place or not. If it's an Occupational Health and Safety Act issue, then obviously for harassment issues the investigation is mandatory, but for other matters the preliminary review will determine whether to conduct an investigation or not. Once the decision is made to conduct an investigation, the next step is who will conduct the investigation, whether it's going to be an internal person, an internal employee of the organization who will conduct the investigation, or whether it's going to be someone outside of the organization, an external person who will conduct the investigation. If it's an internal person, then the employer has to decide who is the appropriate employee to conduct investigation, whether this person could be a human resources person, whether this could be a manager, and a supervisor, or another employee who is competent, who has no conflict of interest, and so there are other factors that an employer needs to consider to make sure that an appropriate employee is assigned for the task to investigate. And we'll provide separate lectures on selecting an appropriate investigator and how do you figure out who is the right person to investigate based upon the specific circumstances of an investigation. So we'll cover that. If the employer decides that it is going to be done by an external investigation, one of the factors that the employer may consider is whether the investigation needs to be conducted by a lawyer or a non-lawyer, whether it could be someone who can simply conduct a fact-finding mission without having a clear or deeper understanding of the legal issues involved, then a non-lawyer may be suitable. So again, with respect to the selection of an appropriate investigator, we'll provide a separate lecture and we'll cover this topic in more detail. Now, how is an investigation conducted? Some of the common steps in a workplace investigation are as follows. So first of all, an investigator is assigned, whether internal or external investigator. And then the investigator is provided with a mandate. What is the scope of the investigation? Is it only fact-finding? Or the investigator has to dig deeper into related matters, for example, breaches of policies and breaches of law, and whether the investigator is being required to provide an opinion on policies and procedures, on law, or any other recommendations that the employer may be seeking from the investigator. The employer will also prescribe a timeline for the conduct of the investigation. Usually the expectation is that the investigations are commenced and completed in a reasonable time period. Once that is done, then the role of investigator begins. Investigator starts gathering facts and evidence. In that process, the investigator gathers all documentary evidence that may be relevant to the understanding of the issues that have occurred. The investigator may get viva voce evidence, and the investigator will most likely conduct interviews from a number of witnesses to figure out what has truly transpired in that specific instance. And once all of that is complete, the investigator will review all of the evidence and all of the facts and then provide a report to the employer regarding the outcome of the investigation. So what is it that you want to keep in mind with respect to a workplace investigation? That a properly conducted workplace investigation is usually very helpful to the employer in understanding what has happened, what caused the issues that became the reason for the investigation, how to maintain a safe and productive workplace environment, and to make sure that the future instances of similar nature, similar disruptions do not occur at the workplace. So in our future lectures, we'll talk more about workplace investigation and some of the specific topics. For example, choosing an appropriate investigator, how to conduct a fair and unbiased investigation. So we'll cover those topics in our future lectures. But thank you for watching this, and hopefully this gives you a basic understanding of what a workplace investigation is. Thank you.